Living Trust Funding Services in Syracuse. Many Syracuse families spend time and money creating a living trust, then set the document aside without realizing it has absolutely no legal power until it is properly funded. Funding a living trust means transferring legal ownership of your assets from your personal name into the name of the trust, a completely separate step from simply signing the trust document. Without this critical transfer, your trust cannot help your family avoid probate court, manage your finances if you become incapacitated, or carry out your final wishes under New York law. New York's Estates, Powers and Trusts Law, specifically EPTL July 1, 18, requires formal asset transfers for a trust to be legally valid, meaning listing property in the document itself is simply not enough. Assets that are never retitled in the trust's name remain part of your personal estate and will pass through Surrogate's court probate, defeating the entire purpose of having a trust. Think of it this way: creating a trust without funding it is like buying a safe and leaving all your valuables sitting on the kitchen table. For Syracuse homeowners, transferring real estate into a living trust requires preparing a new bargain and sale or quitclaim deed, executing it before a notary, and recording it with the Onondaga County Clerk. New York also requires submitting both the TP 584 Combined Real Estate Transfer Tax Return and the RP 5217 Real Property Transfer Report to the County Clerk, even when the transfer qualifies for a tax exemption. A transfer to a revocable living trust where you remain the beneficiary is exempt from real estate transfer tax because it is considered a mere change in the form of ownership rather than a change in beneficial ownership. Homeowners often worry that moving their home into a trust will trigger the mortgage's due on sale clause, but the federal Garn-St Germain Depository Institutions Act specifically protects you from lenders calling the loan due in this situation. For financial accounts, most banks and brokerages allow retitling directly into the trust by presenting a certificate of trust, which confirms the trust exists and names the trustee without disclosing the full terms. IRAs and 401k accounts must never be retitled into a living trust during your lifetime, because doing so triggers immediate and severe income tax consequences that can devastate your retirement savings. Frederick P. Davies has guided Central New York families through the trust funding process since founding his law firm in 1993, and his partner William P. Davies holds an advanced law degree in estate planning. William also served as president of the Estate Planning Council of Central New York from 2023 to 2024, reflecting a deep commitment to this area of the law. Working with a knowledgeable attorney ensures your deeds are properly drafted, your forms are filed correctly, and your trust is fully funded so it actually works when your family needs it most. Call Davies Law Firm to schedule your telephone conference today, located at 210 East Fayette Street, Syracuse, New York, 13202, and reach a trusted estate planning lawyer by dialing 315-472-6511.